Hello, and welcome to a recap of our February 6, 2026 newsletter. We talked about copyrights and salchows and figure skating and the Winter Olympics and even Blades of Glory and Chazz Michael Michaels. We talked about the Super Bowl commercials, including the one involving Will Shat, a couple involving Hellmann's Mayonnaise, and even Budweiser commercial that led to some registered trademarks. We also answered a frequently asked question asking if you have to wait until the U.S. Trademark Office approves and registers your trademark before you can start selling products under that trademark. We also had dog picture and some trivia questions. I'm Tom Vanderbloemen. I'm a lawyer in South Carolina. Our firm practices in the area of trademark and franchise law. We also help clients with patents and copyrights and other business matters. If you like this kind of stuff, or if you just want to see dog pictures and answer some trivia questions, you can sign up for our newsletter. You can see the link in the description below. You can also like this video and subscribe to our channel. So did Chazz Michael Michaels ever run into copyright issues when he wanted to use music in his figure skating routines? Chazz Michael Michaels was Will Ferrell's character in the silly movie Blades of Glory. So why bring this up? Well, this past week was the start of the Winter Olympics in Italy, and there's a Spanish figure skater named Tomas Lorencarino Sabate who was in the news because of a Minions-themed routine that he wanted to use in his competition. He wanted to use music from the Minions movie and was sort of dressed like a Minion also. So what was going on here? What was the issue? Well, under copyright law, there can actually be several different kinds of copyrights and several different owners of those copyrights. There's a copyright in the underlying musical composition itself, what you might call the song, right? And there can also be a separate copyright in the recording of the song, because the song itself requires some creativity when you write the lyrics and you write the chords and you put it down to music. But then there's a separate creativity process, if you will, for the recording of the music in a recording studio or whoever handles that recording of the music. So you can have two different copyrights, one for the song, one for the recording of the song. Taylor Swift fans will certainly appreciate this, and that the owner of the song might be different than the owner of the recording of the song. You may remember there was a story not too long ago about how Taylor Swift re-recorded all of her masters or remastered all of her songs. That's because she didn't actually own the copyrights in some of the original recordings of her songs when they were first recorded. So you can add to the mix in copyright law the fact that there are different kinds of licenses you need, in addition to the different kinds of copyrights that there might be for music. A performance license, which is what it sounds like, gives you permission to perform the song. And that's often granted by performance rights organizations, or PROs. You may have heard of the American Society of Composers, Authors, and Publishers, or ASCAP. That's a PRO, or a performance right organization. There are other kinds of PROs out there. There's Broadcast Music Inc., or BMI. That's not the kind of BMI we worry about when we're trying to meet our New Year's resolutions. There's another one called SESAC. That's the Society of European Stage Authors and Composers. These performance rights organizations are what you frequently hear about when bars and restaurants need to get a license to have live music and performances. And frequently, these bars and restaurants will get letters demanding license payments if they don't already have a license with one of these organizations. Sometimes you need a license with more than one organization, depending on whose library of music you're using. And it's a frequent misunderstanding for bars and restaurants who get these letters. And, you know, in an age where there are lots of scams out there and Nigerian princes and the tax resolution department calling to help you with your tax problem, it's understandable that sometimes these demand letters find their way into what we sometimes call the circular file folder, otherwise known as the trash can. But if you're a bar and a restaurant and you get one of these letters, you might want to give it a second look. They are not always scams. And in fact, these performance rights organizations do have a right to obtain licenses on behalf of the artists that they represent. Now, there's also a different kind of license that may be needed if you're going to sync music to a video or to audiovisual material. That's called a sync license. So the performance license you get doesn't necessarily cover the sync license that you may need to sync that music to the video. So in figure skating, this comes up because there's a performance going on where the figure skater is performing to the music. That would probably involve the performance license. But then also there may be, if there are television recordings, streaming, other kinds of video that's created of the performance with the music in the background, there may also need to be a sync license. Apparently for figure skaters and for other kinds of performance, cheerleading, dance, things like that, there is a group called Click and Clear. And Click and Clear claims to work directly with record labels and publishers to pre-clear their content for use in your music. Now, the Spanish skater at the Olympics said he thought he had received the proper approvals through Click and Clear, but apparently additional approvals were needed, and he was thinking he wasn't going to be able to skate. And it was only this past Friday, that he got the full approval to be able to use the music for his routine, which was going to happen on the following Tuesday. So he probably had a little more restful weekend in Italy as he was getting ready for the Winter Olympics. Now, for what it's worth, those of you who've seen Blades of Glory will remember Chazz Michael Michaels, that's Will Ferrell's character, and he only wanted to use one song and one song only, My Humps from the Black Eyed Peas. Let's hope he got permission too, because we don't want them taking away his Christy Yamaguchi Lifetime Achievement Award. Trademark lawyers like watching the Super Bowl for the commercials too. Consider the legendary Budweiser "What's Up" commercial. Many of you may remember that. It may date me. That's not the only thing that dates me. But I looked that one up and found at least 11 different trademark applications that were filed by Anheuser-Busch just for that phrase, "What's up?" We understand that the commercial aired before the Super Bowl that year, but it was really because of its exposure during the big game that year that it took off. The previews of this year's commercials include one involving the original Captain James T. Kirk from Star Trek, otherwise known as William Shatner. He serves as the brand ambassador for Raisin Bran, touting its fiber content, and he uses the nickname, wait for it, Will Shat, which of course leads to lots of jokes in the commercial. This reminded us of the Saturday Night Live skit for Colon Blow, a cereal which proudly claimed to have 30,000 times the amount of fiber as a regular fiber cereal. That commercial starred one of our favorites, the late Phil Hartman, who also did several voices for The Simpsons, like Lionel Hutz, the lawyer, whose law practice was called I Can't Believe It's a Law Firm. Another commercial for this year's big game is for Hellmann's Mayonnaise, where Andy Samberg plays Neil Diamond singing Sweet Sandwich Time, which may have involved a sync license if you think about it. Hellmann's is no stranger to spoof commercials during the big game, as shown by last year's When Sally Met Hellmann's, an homage to a great Rob Reiner film. You can get to links of these commercials in the description below. We'll likely post this video after the game, so we hope you enjoyed the game and the commercials, and maybe saw some trademarks while you were at it. Do I have to wait for the U.S. Patent and Trademark Office to approve my trademark application before I can start selling products using that trademark? No, not really, but let's explain why and discuss the process. The U.S. Patent and Trademark Office registers trademarks, but it doesn't grant or revoke permission to sell products. There's certainly many unregistered trademarks in use out there on products without any kind of application having been filed. However, a U.S. trademark registration can be very beneficial, as it creates a legal presumption that the owner has a right to use that trademark in the United States on the items listed in the registration. Now, there's also a process that allows a business to file a trademark application based on an intent to use a new trademark, before the trademark has even been used. This allows the Trademark Office to examine the application and see if there's any kind of conflict with other active trademarks in the U.S. trademark system. If the U.S. Patent and Trademark Office doesn't see any conflicts and no one opposes the trademark application, this can be very helpful in giving the business some idea of whether anyone is likely to challenge the use of that trademark in the future. A business using that process still has to start using the trademark to eventually complete the registration process. And other companies can still object to the trademark after the trademark registration is issued, but applying this way can at least give the business some peace of mind. Trivia from last week, for those of you who are curious, we talked about Will Ferrell, and Will Ferrell played the role of Chazz Michael Michaels in the Blades of Glory movie. But another actor, who was actually the producer of that movie, was initially cast for the role. Now, that actor didn't play in that movie. He was the producer, but he did play in many other comedy movies, including Dodgeball and Happy Gilmore and as Derek Zoolander. And speaking of Super Bowl commercials, he's also in a Super Bowl commercial this year for Instacart. Who is this actor who brought us Blue Steel? I can't do Blue Steel, but who's the actor? Send us an email if you know, and if you want to be considered for the trivia. Now, if you like trademark and franchise law and like this video, please like and subscribe. And even if you don't like trademark and franchise law, you might enjoy seeing our canine law clerk at work or the occasional trivia question. We hope you enjoy.